Okay, good morning, everybody. Wednesday, July 29th, time for another Watercooler Wednesday. Watercooler Wednesday, we bring you new case studies, empowering ideas in the note investing area. Also pertains a lot to people who are in the regular real estate arena as well. So if you enjoy the show, please let people know. Share it, go to YouTube, subscribe if you will, and I'd appreciate that. But if you want to help us out and reach more people, please go ahead and share this link and all the social media that you can find us on. Joined by Dwayne Gibbs. Dwayne, what's happening?
Hey, good morning. How are you?
Good. Fresh off my morning workout. If got up a little earlier
Pumped
today.
you
I
up. You got your
beat
pump
the
you up.
beat the sun a little bit too. So yeah, lifted
Yeah.
weights and went for a little walk, and now I'm ready to go. But I was up early and I like to make these truly informative. And last week we talked about mortgages and deeds of trust and the property ownership and things like that. That I mentioned last week that those are details. And in this industry, I mean, what really separates a novice investor from somebody's going to be in this a long time, it's the details, everybody. It separates the men from the boys, the girls from the ladies. I mean, it just does. Because if you don't have the details in this business, that's what's going to come around and hurt you eventually. And it really bothers Dwayne, it bothers myself that there's a lot of free education out there, everybody, and everybody's like, oh yeah, I can learn all this stuff for free. Yep, you can learn the basics, you can learn the overviews, you can learn all that for free, guarantee you. You know,
Yeah.
but you know what's going to happen? Number one, you're not going to have the details to probably move forward and get a first deal. Or if you get your first deal, you're likely to run into some problems in getting that started. You'll be frustrated. But sometimes, hey, you get lucky and you buy a deal that,
That it
despite you
goes
not knowing some
perfect
things, it goes well. And then you get into this
until it
false
doesn't.
sense of, yeah, you get the false sense of, oh, see, I told you I could get it for free, and this is easy. And then you're on to your next one, and guess what? Eventually, the numbers game catches up, everybody. And that's why with my trainings, it's very, very detailed. And it needs to be because it's in those details that the business really is built upon. It just makes you stronger, smarter, safer, higher returns, and longevity, everybody. So it just makes sense to do that and understand. Look, there's a cost to education. So trial and error can be expensive. Or, it's been proven time and time again, you work with somebody who's willing to share their experience, their knowledge with you. And you can go back from the beginning of time. Guess what works? That works. Okay. So that's what I try to bring you. And I'm going to share with you some details on a topic that is brushed over. And I hopefully I have time to do the whole thing, but this is going to be a really good lesson and just a really good idea to show you a visualization to show you why this details matters. I mean, these are the sort of things that I go over with my students on a regular basis on all my courses and everything else. So I'm a big advocate of doing just that. So I had some good time to do that and get some stuff prepped for you. A lot of stuff I already have prepared, obviously from lessons and things like that I'll tweak from time to time and just make them that much better. Constant, never-ending improvement sort of concept, if you will. But right now was a good time because I'm waiting on six BPOs, six title reports, and it's driving me nuts.
I
You
bet.
reach a point where you're like, we're ready to close. All I have to do is verify that the property's worth what I think it's worth and verify that there's no issues with the title. Trust but verify, as we say all the time. Once I get that, we're ready to go. But man, third parties can hold you up sometimes, and it gets a little frustrating. But hey, it gives me time to bring these concepts to everybody. So one of the things that is unique in this business is contract for deeds. Okay, so we talked about mortgages, we talked about deeds of trust, covered that. You can go back on YouTube and watch that, and I would recommend that you do that. That was last week. And I mentioned that there's this other hybrid that is out there called contract for deeds. And if you're going to get into the note business and you are not familiar with contract for deeds, you're going to miss out on opportunities, or you're going to get into deals that are not good, or you're not going to protect yourself the right way because of the nature of these deals. So again, it's one of those things that it's in all of this notes and mortgages, these are the most challenging, these contract for deeds. Okay, so it's got to be laid out for you what works, what's advantageous of having them, of buying them, what is disadvantage. And same thing, I'm also going to teach in here what advantages are there, or what steps do you take to look at it if you're a lender, somebody's buying real estate and selling it. So I've broken it down for you in some easy steps here, I think, and then Dwayne will keep me, if I go off the tracks or something like that, let me know, or something's not clear, you let me know on this. All right, I'm gonna share my screen. I've got it all laid out for you here, and this is a little mastery of note investors. You won't hear probably 98% of this anywhere else. It's just not taught. All right, so tune in. Here we go. Contract for deeds. So here's what we're going to cover. What are they? Okay, so you have to identify what the heck they are. You have to know the differences between them and traditional mortgages. You have to know, like I said, the benefits and the drawbacks for all parties, for the buyers, for the sellers, for the note investors. You have to know the state laws. Okay, now I don't expect you to know all the state laws, but guess what my clients get? They get an Excel spreadsheet that I maintain all the time that shows what all the various state laws are, okay? Because it is that important. We're going to talk about if you're buying these contract for deeds that are already been created by somebody else. We're going to talk about if you are buying real estate and selling it on terms using seller financing. Very popular to do contract for deed, but is that the right way to do it all the time? We're going to talk about that. And then when selling a contract for deed simply may not make sense for you to do, where you might have to think in terms of maybe I should convert it. Okay, so that's another possibility here. So a lot to cover in a short period of time here. I spend more time with my clients on this, so hang tight, everybody, but you'll learn quite a bit from this. Okay, what is a contract for deed? And I didn't have time to build in build-ups on the PowerPoints here. I just put the all the points up. So very simple. A contract for deed happens with seller financing, not with banks. Banks do not lend under a contract for deed. They can't do it. The rules aren't there for them to do it. They can't sell their paper that way. They don't do it. You will only find contract for deeds with seller financing. So that could be seller financing from an individual, a small company, a bigger entity that's buying a lot of real estate, turning around and selling them with financing. That's where contract for deeds come from. So we're not operating with these under the same mortgage rules. This is more under contract law, and there's a distinct difference in this. So seller financing doesn't have to play by all the same rules that traditional financing does. And that includes, by the way, mortgage qualification and everything else too, but especially when it comes to contract for deeds. Now, contract for deeds allow this. The buyer of the property is going to make monthly payments to purchase the real estate. That monthly payment is going to include that should be interest and principal. I got a little typo there. Let me fix that right now. Okay, principal and interest. All right. The seller, though, is going to retain what they call legal title to the property until the final payment is made. So if I'm selling a property to Dwayne under seller financing, he's likely to give me a down payment, and then he's going to promise to pay me back on a monthly installment plan for the rest of it. So if I'm selling him a $100,000 house, he gives me $10,000 down. We create a $90,000 loan, seller finance loan, but we make it a contract for deed. The arrangement is, Dwayne, I'm saying on the title to the property until you pay me off in full. How do you pay me off in full? In monthly installments. You want to pay more? Great, no prepayment penalty. You can certainly do that. But I'm going to stay on the title to the property because possession is 9/10 of the law. And if you don't pay me, Well, I already have the legal title, so that's one less thing in theory that I don't have to go after if it becomes non-performing. Now, what we're giving up and why this is a better thing for Dwayne than just a lease. Well, if he were to lease the property, he has no entitlement to the equity. He's just paying monthly payments to stay there, right? And can renew that and that sort of thing, and has to upkeep the property or, that sort of stuff where his deposit goes away. Everybody gets that. This is better than renting because he does get what's called equitable title. An equitable title gives him the right to occupy it, improve it, build equity in the property. A lot of times there's agreements where he's going to maintain it up to a certain dollar amount, that sort of thing, because really he is going to be the owner of the property and get full legal title at some point in time. But in the meantime, he is establishing equity. In other words, if he sells that $100,000 house that he bought 5 years later, he sells it for $120,000. All of that equity, the difference between what he owes me, let's say $95,000, and what he sold it for 120, all that equity goes to Dwayne. That was his equitable title. Okay, so that's what he's building over this monthly period of time. He's working towards the ownership and he's chipping away at equity every single month because hopefully the property's going up in value. You establish equity that way, and he's paying down the principal the principal debt, and that's establishing equity for him as well. All right, very important to know that. So when paid in full, the agreement is I have to deliver the deed to him. Okay, that might be a quitclaim deed. It might be a warranty deed. That's normally written out very specifically in the document, the contract for deed is written on. Okay, so very common on all types of property. We see them on vacant land. We see them on rural property, residential property, you name it. Very, very common thing for people with seller financing to do because they like to be on that legal title in case things go bad. Sometimes they can be shorter as well, but so can mortgages. So there's no real difference there. They can be set up with balloons. They can be 5 years, 15 years. They can be 20 years, 30 years. So just the same as a mortgage can be done. So that's what they are. It's a tool that people use in seller financing where they want to have some of these advantages, such as legal title, while giving up some of the other things, such as equitable title. Okay, that's what they are, very, very simply there. So how does it work? Dwayne and I negotiate a price. Okay, he's buying the property. I'm selling the property. Maybe I bought a foreclosure. Maybe I fixed it up. Maybe it didn't need renovation, whatever. I bought the property. I'm selling it to him. We negotiate the price, the down payment, the interest rate, and the terms. Now, if I'm a smart note creator, if I know that I'm going to sell this property creating a note, I am largely dictating those terms to Dwayne, right? Dwayne's not going to be the tail wagging the dog, so to speak, right? He's not going to be, well, here's the only way I'll do it. I'll be like, yeah, I don't think so. I'm going with somebody else. Okay. So that's, really how that relationship's going to work. Now, I might be sensitive to Dwayne as to what monthly payment can he afford? Right? Because then I can start to work with all these other numbers. And if I know what the payment is, that might change the term. Maybe he can afford a higher payment. Well, I'll shorten the term then. What about the interest rate? So I'll start to work within those numbers, certainly to create the best note, because in my mind, at some point in time, I might want to turn around and sell the note to somebody else. And I want to get as much as I can. I don't want to pay or suffer a larger discount than is necessary. Okay, so we negotiate that. We write up the document, the contract for deed. There's usually a note attached with that as well. I stay on the title to the property. I'm already there. So he moves in and he's paying me typically directly. Now, they can be professionally serviced, and I recommend that. The buyer, Dwayne, in this case, is always going to be written in the contract. He's going to pay the taxes. He's going to pay the insurance. Now, we might be doing that through escrow, or we might just tell Dwayne, that's on your own. We're not going to hold escrow. I'm okay either way, quite frankly. Most people prefer escrow, and that's fine. But if you're self-servicing, escrow becomes kind of an issue. So it depends. Now, Dwayne, we continue this relationship. He's taking care of things. He's paying taxes and insurance, etc. I'm just kind of collecting the payments. I'm the bank, so to speak. And then he pays me off, maybe in lump sum, maybe through the totality of the payments. At that point in time, I surrender the deed. Okay, a lot of times you do that through a warranty deed. So I surrender the deed, give that to him. Who records that and pays for that, by the way, probably should be written in the contract for deed to begin with as well.
Kevin will.
I'm going to want him to pay for it. He's going to want me to pay for it, right? But that should be written into the contract. If the buyer defaults, okay, so best case scenario, he gets the deed, we're all good. Worst case scenario is he can't. He can't make the payments anymore. Then the seller may forfeit the property, okay? Or we have to foreclose. And that's where the state law comes into play. You can create contract for deeds in every state, but not every state has a law specifically for contract for deeds. They don't recognize them as a full contract for deed as it's written. They think of them as mortgages. And if your state thinks of it that way, then they're going to make you foreclose anyway. And we'll talk more about that in just a minute. So the seller may forfeit is a nice way to saying that I'm going to go to him and file paperwork and go, dude, you've got 90 days here that you're late. I'm demanding payment in full. I'm going to accelerate the loan. You've got 30 days, or maybe the state says 60 days to come up with all the money. He doesn't come up with the money. I file the paperwork to evict him, and he's out. Or he could walk away. And by the way, I did have somebody just walk away from one. Unfortunate circumstances. She was a great payer, but she got very, very sick and just emailed and said, I'm so sorry. I can no longer afford to pay this. I have to get another surgery and I just can't do it. What can we do? And I said, you know what? If you just sign the property, sign your rights over, we'll dissolve the contract for deed, and therefore none of your debt obligation is alive anymore. We're just, bad way to put it. We're going to forgive all of your debt. You just agree to give up all of your rights uncontested, forfeit your rights. Great. And that's what she did. So we got the property back. We're going to sell it to somebody else and do the whole thing over again. So quite different between a traditional mortgage. Now, I say traditional mortgage, and don't forget deed of trust are mortgages as well. So if you're in a trust deed or deed of trust state, that is a type of mortgage, by the way. Okay, so let's go through the difference here. Who holds the legal title? Again, if it's a contract for deed, the seller does until paid in full. If it's a traditional mortgage, the buyer gets the title. That's how it works. Security. The seller keeps the deed. I'm still on the deed. That's my security. In a traditional mortgage, the lender holds a lien, a claim against that property in which they can file a judgment to redeem it. Okay, big difference. Qualification. If I'm doing seller financing, I basically decide if the buyer's qualified or not. I don't have to abide by Fannie Mae guidelines for credit. Credit's really not an issue. I do with Dodd-Frank today have to make sure his debt to income ratios are acceptable, but my ratios are different than banks. They can be 55% debt to income ratio. So quite more flexible than banks, which are going to look at credit scores, they're going to look at income rules, they're going to look at all those things. You're going to want more documentation, et cetera, et cetera. Now, I could and have the right through the contract for deed to do full underwriting, and there's companies that do that for us. And that's an important step because I don't want to sell it to somebody who's not really qualified, can't afford it. And number two, if I turn around and sell the note down the road, I want to be able to show them, yeah, I looked into this person. We verified his income. We verified his taxes, all those sorts of things. We've done that. And that increases the value of that contract for deed, by the way, versus not having it. Okay. Closing speed. Again, traditional mortgage, you're probably looking at 30 to 60 days, depending upon your credit and down payment. With the contract for deed, you can close them really quickly. Okay. A couple weeks. Doesn't always go a couple weeks, might be 30 days, but they're much quicker. Default remedy. So if it goes non-performing, it's either a forfeiture or a foreclosure. It depends upon the state. Like I said, I have for my clients, boom, here's every state. Here's what the law is. And by the way, I have also on there, do you have to record it in that state or not? Because some states it's legal, but you don't even have to record it. You can file a memorandum instead, or you don't even have to do that, right? So it's nice to have those tools. Traditional mortgage, it's a formal foreclosure process. Again, that would be judicial or non-judicial. So buyer protections, this varies. And again, this is what most people who do seller financing with contract for deeds don't take into consideration. They just learn contract for deeds and they do them everywhere and treat them the same everywhere. That's a mistake
Mm,
because not every state looks at them through the same lens.
that's right.
Okay. So it varies. In some states, for example, once they establish 20% equity, the state's going to help them protect that equity. They're going to go, wait a minute, this person's been paying for 10 years, and you're going to come in and just take the property away from them on a forfeiture because they were 90 days late? We don't think so. We
That's right.
protect our consumers a little bit more. Okay. Things like that. So the interpretation of that, really depends. Okay. If it's vacant land, they might treat it differently than if it's a single family home. Okay. With traditional mortgages, there are stronger protections, of course. There's states that have very strict guidelines on what the foreclosure process is, and they have various resolutions and those sorts of things. But there are buyer protections in place in state laws, and that's what you have to be familiar with. All right, so some of the
I'm
key,
glad you did that because that's helpful. I was going to say, hey, we
yeah,
ought to do a pros and cons list, but should I have known, you already were ahead of me and have done.
got it right there. All right, so key differences. Title stays with the seller. Okay. And this is important. So if it stays with the property seller, that's where it gets a little more complicated with the state law nuances to go, well, wait a minute. You can't just kick this borrower out because they may not have legal title, but they do have equitable title. Okay. So remember, I said there was equitable and legal title. So it gets a little more complex. And you have to have, if you're going down the road of enforcing the contract for deed because the loan is not performing, you need an attorney. You need an attorney, and you need an attorney who's a specialist, not some attorney who does title closings, and that's all they know is the Fannie Mae forms and all that BS. Most attorneys are not educated in this area. You have to find attorneys who are. Okay, important distinction there, everybody. I'm just telling you, you don't want to pay for an attorney so they can learn contract for deeds, right?
Mhm.
All right, so
Off of your expense.
yeah. So no third party lender, right? So that means fewer closing costs, faster deals. So if you're buying real estate, turning around and selling it, and you're creating the financing, you're saving those costs. You have all those sorts of things. I would do the underwriting and pass that cost on to the borrower because after all, hey, you want me to give you a loan, you at least got to pay $600 and get qualified. If you're not willing to do that, maybe I'm not willing to give you the loan. You know.
Mm,
Interest rates obviously are going to be higher on seller financing. If somebody could get a bank loan, well, go get the bank loan. Can't get the bank loan? Why? Credit, down payment, don't have proper paperwork, don't have a good enough job history. There's a reason. Well, if you can't get bank rates at 6%, why would I lend you at 6%? So most of the time, you're going to find these interest rates are going to be between that 8 and 12% spot. Recording of the contract for deed. Very important. Sometimes it's required. So um, it really depends upon the state. And a lot of people who do this, again, they're so just, they figured one way to do contract for deeds and they just don't record them. Well, some states require that you do.
hmm
Now, there's no contract for deed police that are going to come out of the woodwork and say, hey, you didn't record this. They don't know that you created it. None of that stuff comes up until you go to enforce it. So the loan goes bad. Now you go to enforce the contract for deed. They're like, you never recorded it. And that's going to cost you time and money. You might still win, but I guarantee you that's going to put you in a category where you have to foreclose, whether the state has a contract deed law or not. Okay, because you
hmm
didn't follow what you were supposed to do. So if it's required, you got to do it. Sometimes it's required with just, which I like, with just a memorandum. Because in the memorandum, it can be like, hey, Dwayne and I have this private deal here. We're just letting you know that it does exist, but I'm not showing you the interest rate that Dwayne's paying. I'm not showing you how he worked the deal. I'm not showing you what the down payment was, what the monthly payments are. I'm just memorializing the fact on both of our behalf that it does exist and we have that in separate place. And some states like Michigan, that's allowable. And that's what you see. So don't just look at a contract for deed. Oh, they don't have to be recorded. It depends upon the state. Okay, it really depends upon the state. So if you're buying a note and it's a contract for deed, I should say, and you look up the law and you see, hey, this is supposed to be recorded. You guys didn't record it. When's a good time to have them record that? Now, not after you buy it. Okay. After you buy a note, the person received the money that you sold, that sold the note, their motivation to do anything, especially record something, it's gone, evaporates. So you got to understand this from both sides. Okay. All right. Other states, they say, no, you don't have to record it. A lot of the ones that say you don't have to record it, guess what? They go, because we don't even recognize it. In our eyes, it's a mortgage anyway. Okay. So what's the point then? Is it worth it to have the contract for deed? Well, we'll find out. Secondary market for contract for deeds is thinner than regular mortgage notes. There are still some investors to this day that just don't want to buy contract for deeds. And I get the whole background and reason for that. I could explain what that whole thing is. I don't want to go down that rabbit hole. Just understand that there are some investors that for various reasons don't want to buy contract for deeds. They deem them too risky. And again, it's because of lack of understanding, etc. And I'll leave it at that. But just understand that if you're creating those. So property buyers, let's talk about them. For property buyers, are there benefits to this? Absolutely. And that's why you don't want to see something like the Dodd-Frank Act make this stuff go away, because then people don't have access to housing. All right. It's easier to qualify. Credit challenges, we don't care. Dodd-Frank doesn't say anything for seller finance notes, especially under contract for deed, that we have to look at their credit. We don't. Could care less. Look, Dwayne's buying this and he's putting 30% down. I'm not even thinking about his credit. I don't care what his credit is. He just put $30,000 down on a $100,000 house. We're good. Okay. Now, can you afford the monthly payments? If I want to have a qualified note under Dodd-Frank, then I would look into that. That's it. That's the only thing I have to look at. So, Dwayne, how much money do you make every month, and how much of that would be going towards the housing payment? That's all I need to really know. Now, you can get a Dodd-Frank qualified and everything else, but that's another presentation.
Episode.
All right. Faster closings, lower upfront costs. I might not even charge Dwayne points and fees. It's whatever I want to do on the loan. When are you ready to close it? I don't know, Dwayne. When do you got your 30 grand? I'm ready. What else do we need? We do the paperwork. Okay. It's all templates, right? If you want to have an attorney do it, great. You have an attorney do it. You want to have a title company do it? Have a title company do it. It's up to you. Path to ownership when banks say no. That might be the only way that your borrower can buy a house. And that's what I mean. If laws got away, said you cannot do these sorts of things, well, they're going to keep a lot of people out of the housing market. All right. Benefits to the sellers and creators. So if you're creating a note, in other words, you bought the real estate, now you're selling with financing, you've taken a house that you're trying to put on the market, and where your neighbor's house, the buying pool is this large because they're just offering, no financing at all. It's bank financing. So they have a limited amount of buyers. Okay. Yours, much greater, because they don't have to be bank qualified to purchase that property. The other thing is this: remember, banks don't do mortgages, first mortgages to buy a home unless they're over 80 grand. A lot of the case studies, if you go back and look at the YouTube channel, you go back and look at my social media, you go on the website, see some of the case studies that I'm doing, follow me, whatever, you'll see that we're dealing in houses that are 100 grand, loans that are started at $80,000 and such. Can't get that from a bank. Where else are they going to get it? From us. And you can offer seller financing on that. High interest rate income because you're charging more than bank rates. And potentially, once again, yes, there is faster repossession in some states that fully recognize the language of contract for deeds. That's why a lot of times when you're doing due diligence, you'll see within that not only is there a contract for deed, but there is a referendum, a second notice that says You are acknowledging that this is a contract for deed. It is not a traditional mortgage, and you have been given the right to run this by an attorney and blah, blah, blah. So it's hard to go into court going, well, I didn't know what exactly what it meant. Here's a referendum that says that you did. So whether you read it or not, you signed the dang thing, and that's what you have to live by. Okay. So yes, there are in some states faster repossession, but not every state, once again. So for note investors who are buying these that are already existing, you didn't create them. Okay, the creator's now looking to sell them. You buy them at a discount. Why do you buy them at a discount? For reasons I've already covered. Because they didn't record it in that state. They didn't do the proper steps involved. There's always going to be something like that by the people who are creating that most all the time because again, lack of knowledge in that particular area. Plus, don't forget you're trading present day dollars for future dollars, and you've got to think in terms of that. What's that going to cost if it does go bad? So we purchase about a discount, and that should put your yield really between 10 and 15%. I put 9 on there, be a little gracious. Passive cash flows, I would use a servicing company. Always, always, always. Again, for compliance. Compliance for the legal process later on. If you have to take legal action on it, it's nice to have that third party where all the numbers are there, trusted, verified, licensed, bonded servicing companies. And you know what? If there needs to be debt collection, they're licensed. You're not. And in some states, that's important. Okay. I had an attorney tell a client he's got to be licensed in all these states as a debt collector. I'm like, no, you do not. Your attorney doesn't know what they're talking about because you're not self-servicing the loan. Not if you're working with me. Okay. It's going to be at a servicing company. They will do the debt collection under their license on our behalf. And we give them a limited power of attorney to do that. Okay. All right. Secured by real estate, same thing. So we're getting all those same benefits that we get buying a note in a mortgage. Really, it's really the same. A lot of times with these contract for deeds, because there's potential for more errors, we do get them at a higher discount. But we also have to recognize that there's some potential errors there. Now, there is some downside. Okay, so downside drawbacks here for the property buyers, and then I'll talk about what downside for us. For a property buyer, their downside is they don't have legal title.
Mm-mm.
Okay, so they can't really, well, that's a mistake there. No legal title. If they don't have legal title, they can't refinance it. We can allow them to refinance it. We can title it over. We can do something like that. They also can shoot. I forgot what I was going to say there. So, oh, their debt. If they on the positive side for us, I guess, and jumping ahead there. But if they're not on the legal title, no liens can be put against them. So if they have a hospital lien, they got hurt, something like that, the hospital can't put a lien on this property because they're not on the legal title. Okay. So if they're not on the legal title and they go to a bank and say, want to refinance, it's like, no, you're not refinancing it because you don't own the house. Now, if you want to get a new loan, we could talk about that if you qualify, that sort of thing. Okay. So they can't borrow against it. They can't go to home equity loan, anything like that. And that's probably what I meant. Can't easily refinance. Whoops. Whoops, whoops, whoops. Okay, can't do that. That's what I meant. All right. They do run a risk of losing all their payments and improvements on the default because it can be foreclosed or forfeited. If it's forfeiture, they can risk all losing everything that they've paid. Now, again, some states they'll have a forfeiture, but they'll also have a forfeiture up to a certain point. And that's going to be based upon the equity in that property and the property type. So it might say forfeiture, but then the smaller print says until they have 50% equity, then we're going to make you foreclose either way. So there are qualifiers for states as well here. So if you're selling the properties, and a lot of people do this, they sell these properties as is with no improvements. That might be to a rehab company, it might be to a consumer. Any work that they've done in there and it's forfeited, thank you. So they do run the risk of that. So these are risk again for property buyers. Balloon payments, that can be a tough one too, because sometimes they'll create these 30-year loans with a 5-year balloon, and then the person goes to get bank financing in 5 years and they can't do it. Okay. Now, most people in our industry would push the balloon back, dissolve the balloon, set up a payment. But if somebody wanted to play hardball and just say, I'm accelerating the loan, you said you'd pay me in 5 years, I'm coming after the property now. Well, that's a risk. Seller could cloud the title. The title's in our name. So technically, if something illegally is upon you and your name is on that property title, you could have a lien attached to that property. That could hurt the property buyer. Okay, so the buyer is taking on some risk, but at the end of the day, these risks are typically disclosed, either point blank, or again, you're giving them the legal right to run this through an attorney and find out what their risks are. But most of the time, what do these folks want to do? They want to buy a house, and the thought process is, let me start paying this, and then down the road, I'll get a loan and pay it off. And when I pay the note holder off in full, then I get title, right? Then I can get be on the loan and the title. Okay, so that is some risk for sure. What about the drawbacks for note sellers and note holders? Okay, so if you're the one creating the note, because you sold the property and now you're holding on to that note, is what I mean. The title remains in the seller's name. So you do have ongoing liability. What if somebody gets hurt at that property? Okay. Insurance companies are going to sue, and they typically go to sue where the money is. And that might be you. So if your name or your company name is on the title to that property, you've got that liability to risk. Now, we can cover that risk through insurance, but you need the type of insurance that has hazard and liability. And there's still people today that have contract for deeds that only have hazard on there, meaning if the house burns down, something like that, they're covered. They don't have liability. That's a dangerous proposition for people to be in, uninsured. So I would have the insurance on there, have it in a company name, have an umbrella liability policy for you as well, and you're okay. Can be harder to sell, as I said. I put a little asterisk there because there are people that don't think any differently of them. They just take more risk out by buying it at a deeper discount. But there are certainly people that don't want to buy them. Courts in some states will characterize these as a mortgage, as I said. So is it worth it to create it and take on the liability, and then the state doesn't even recognize that it's a contract for deed? They look at it as a mortgage. You're taking on the liability without the benefits. Doesn't make sense. Before you got to look at the state law. What about note investors? What about people like me and Dwayne? State law surprises on default remedies. So know what the state law is, okay, when you're looking at buying these. Title insurance can be more complicated because, again, well, who's this party? And okay, they're just borrower, they're not entitled. Is it a rental? No, it's contract for deed. So a lot of times these don't have title insurance on them, okay, which is okay, again, if you know what you're doing, but that's a whole other conversation as well. And the due diligence is a little heavier. A lot of times with these contract for deeds, there's underlying loans. Do you have to record it or not? Okay. Are there other liens that are on there from the seller? Maybe the seller renovated the property, didn't pay a contractor. Contractor can put a lien on that property because it's in the seller's name, not the borrower's. We have to know that going in. So your due diligence goes beyond, just a typical note and mortgage. Okay, so there is a little extra step for us on there. And again, that's why we discount them. So just a quick snapshot. Like I said, my clients have the whole list on this, but there's 21 states that have statutes regulating contract for deeds. So, for example, Illinois, you've got to record it, and there's a 90-day cure. So 90 days after the 90-day late payments, you've got to give them to cure it, which is to come up with the balance that is owed. If it's not recorded, you're pushing back your time frame. Okay, so you can't enact for 90 days, and then after 90 days late, you got another 90 days. If you haven't recorded it, well, guess what? You got even more time on that, which means no revenue coming in. Ohio requires foreclosure after 20% is paid or 5 years have gone by. So there's no real benefit after that. Minnesota, Iowa, statutory cancellation, but strict notice of recording. So in Minnesota and Iowa, you can get the property back through a forfeiture, through more of an eviction process, but you better know what you're doing, okay? Because they have strict notice, and if you don't do it the right way, they're going to kick it up really easily into a foreclosure. Texas, heavy disclosures, foreclosures after 40% or 3 years are paid. Okay. Many other states rely upon case laws. You can see courts treat these as equitable mortgages in many, many states on there. Okay. But it is allowable, from CFPB. They're considered credit. So there is Truth in Lending Act disclosures and things like that that you have to consider as well. Okay. So a little bit different, everybody. Is it worth it to create these or not? Really going to heavily depend upon the states here. So why do some states again treat them as mortgages? They're looking to protect the buyer who's built up equity, and in a way that's really fair. I mean, again, you can't have somebody who's been paying there for 10 years, built up all this equity, fixed the property up, and then you just come in with an eviction process and they're gone. The courts are going to protect that. They're going to at least make you work hard to get that property back from them. And that's how the laws are written. They don't like to see harsh forfeitures. They will take hardship. I mean, if you've got an elderly person, something like that, you think the state's going to allow you to foreclose on them and take everything that they've built up? No, no, no. And don't do that anyway. Result: seller note holder must use the full foreclosure process. And again, if you've got to go through the whole foreclosure process anyway, what's the point? You're on the property for a liability issue, but you're not getting any of the benefits. So cure periods can lengthen, redemptions period, deficiency laws change. So the quick and easy thought process of doing a quick contract for deed can quickly go away. And if that's the case, again, you're just taking on unnecessarily liability without the benefits. Guess what? We can convert these. Okay, so there is a conversion process where you can go to the property owner and say, you know what? You've been such a good payer. How about we give you the title now, and we'll convert this over to a note and a mortgage, or a deed of trust in a note. Either way. And that releases you from being on the title to the property. Okay, so you're away from that liability issue. Okay, I think that's important. Buy the seller's position. For investors buying contract for deeds, if we are the investors, people like me buying these contract for deeds, we're taking over in their footsteps. Okay, so we're just replacing them. So we get the rights of payments, but we have the obligation to deliver the deed. We're going to be on the title to the property, so we do have that extra liability issue there. Let's see. Again, is it properly recorded or not? Do they have clear title? Is there any underlying loans on the property that the seller still has? And a lot of times when I buy these contract for deeds and we do it through escrow, we instruct the escrow company to say, hey, this one has a $20,000 underlying loan. We're paying 50 grand for the note. So escrow company, you have the obligation to pay that 20 grand on the underlying loan. That was the hard money loan that they borrowed. Get that paid off, and then the extra 30 goes to the note seller. We don't give 50 grand to the note seller and say, hey, please don't forget, pay off that 20 grand. All right. Think about the equity that the buyer has built. Because again, a lot of people selling contract for deeds go, hey, it's contract for deeds. So easy peasy, get the property back. No, what if it's not? Discount, and that's where you can point out, now here's the state statute of that. It's past 5 years. So there is no, we would have to do a judicial foreclosure. So that negotiating point is gone, discount. Um, Default language, state remedies, all these things you have to look at. Yields can typically be higher because again, we're taking on a little bit more additional risk in these deals. And anytime we have additional risk, we have to outweigh that with the discounting. And again, use professional servicing, everybody. I know it's $30, $40 a month, something like that, but it keeps you out of
Headaches,
trouble. Um,
less headaches too. It's
oh, and they do
ridiculous.
all the tax stuff for both parties. They do all the
It's
compliance
so
stuff,
worth it.
the licensing. They're secured, they're bonded. I mean, just do it. And I tell my clients, your default position should be to get a BPO and title on every deal, but especially on contract for deeds. Okay, because you want to make sure there's no underlying loans on that CFD because that could hurt you as well. So if you're creating these, the time you're going to want to use them is if you want maximum control of the title. If the state allows a fast forfeiture, it's worth it to do that in the buyer's weak credit and you're just comfortable doing a loan for them anyway, then a contract for deed makes sense because you've got everything working in your favor. It's worth taking on being on the title to the property if they allow fast forfeiture on that. But if you want a cleaner secondary demand, if you want the buyer wants legal title for which they normally do, but you want to be more liquid and just understand that there's no advantage in that particular state to do a contract for deed over a note and mortgage or a deed of trust in a note. Do a mortgage. It's easier. It's cleaner. Recording's easier. Boarding's easier. It's just easier. Uh, Now, some of the things when you have a contract for deed, if the state already requires mortgage style, you lose the speed and advantage to the complexity. Convert it. Okay, just convert it. You're better off. Note buyers discount these deals heavily because they might have to convert them, and that costs money, right? The title remains in the seller's name until paid off. So again, the transfer can be a little messier, and better economics often come from just converting it over. So take a strong look at that. So summary real quick for you because we're going long. Contract for deed, seller keeps the tire, buyer builds up the equity. Big difference in the default remedy. The benefits, yeah, access and yield, drawbacks, complexity and state variation. And again, underwrite it according to the state law. If the state law is not worth it, if they look at it as a mortgage, forget it. Do a note and a mortgage. It's just easier, smarter thing to do. They can be good investments, so I would not completely throw them out as you're a note investor. I think you're making a mistake if you do that. And just, look at it to bring it down to the simple. Will this be easy to sell later on? It doesn't have to be that complicated, everybody. All right, so that gives you, and I know I went through that fast, but think of some of the detail that you got on that versus some of these 1 day or 3 day trainings that you get to, and that's what's going to make a difference is knowing how all these things truly work. It took you 30 minutes to intake that. It'll take you a little bit more to research it, but this one lesson that I've given you today, if you're in this space, that will probably end up saving you tens of thousands or not more dollars just on
It would.
knowing how to handle these things. You may not see it now, but I'm telling you, that's exactly what just happened. So good stuff. Tough topic to kind of go through, but I think I laid it out pretty darn good.
And it was great lesson. Great lesson. A lot of information today. I think that, you know, the pros and the cons of it, how it can benefit you. And you're not going to do this every single time. So it really
Dude.
just depends on your situation. It depends on what's the best fit for you, what's the best fit for your client. And again, that's being a note professional. That's being a deal guy in the business of being able to identify that what's going to be both best for both you and your buyer. And so just be aware of it. I think Kevin does a great job of breaking all that down of what is the best benefit for you and providing a great viable note that if you need to sell it on a secondary market. And so always you can go to his YouTube channel, all social medias. These are always recorded and put out on social media. You can always go through kevinshortell.com, and he also puts out his tip of the day, which is always great information as well.
Yeah, you got it. And go to the website. You can set an appointment with Dwayne, and let's get you on the right track here, everybody. All right. Thanks again, and appreciate it. Thanks, Dwayne, for being on, and
See you,
look
bud.
forward to talking to you all again real soon.